Swayam Prabha. Digital India. Educated India.
Hello all. In the last discussion, we discussed about the various provisions mentioned under Article 101 and Article 102 in the Treaty of Functioning of European Union. So, there basically we looked into what are the provisions laid down as per these regulations. Article 101 specifically tells us about the various association among the undertakings, maybe in terms of vertical or maybe in terms of horizontal agreements, which by any means if it reduces or tries to distort or tries to restrict the competition, then it will be considered as an anti-competitive agreement. And Article 102 basically talked about the abuse of the dominant position. So, in this session, I will like to take you through these assessment of IP based conduct under this Article 101. So, in this section basically we will look into the principles for assessment under Article 101, and in particular we will also through case laws will analyze assessment of IP licensing or agreements under this Article 101. So, as I mentioned, Article 101 basically talks about the restriction of the agreements by the undertakings which in any shape restrict, distorts or reduces the competition in the European internal market. So, to consider whether any agreement falls under this category of anti-competitive in nature, there are basically two principles under which the cases are analyzed. So, basically the assessment under this Article 101 consists of two steps. In the first step under this Article 101 subsection 1, the first assessment is regarding whether an agreement has an anti-competitive object or actual or potential restrictive effect on the competition or not. It means that whether it is directly aimed at achieving anti-competitive object or in some way it will lead to actual or potential restrictive effect. And in the second step, under the provision of subsection 3 of Article 101, the European Commission basically determines the pro-competitive benefits produced by the agreement, and then finally they outweigh the pro-competitive effect with the restrictive effect. If this pro-competitive effect outweighs the restrictive effect, then the agreement is not considered as an anti-competitive, and if the vice versa happens, then the agreement is considered as an anti-competitive agreement. So, these are the basic principles. So, as mentioned in the slides also. So, first it is assessed that the agreement is having an anti-competitive object or actual or potential restrictive effect on competition, and in the second step it is determined that whether the pro-competitive effects outweighing the restrictive effect of the competition or not. And as you know, in the subsection 2 of Article 101, it has been stated that if any agreement is as per the subsection 1 of 101, then it will be automatically it will stand void. So, as Article 101 is regarding the vertical arrangements or horizontal arrangements, for example, the formation of cartels or mergers. So, cartel where a group of independent undertaking come together and by the way of agreement they try to restrict the price or they try to share the common market, and in any way they are restricting the competition, then it is considered as an anti-competitive agreement. So, the Article 101 prohibits the agreements where the object or effect is to restrict competition. So, how it has been assessed that the agreement is having an object of restricting competition or not. So, there the the European Commission basically looks into the agreement, and particular attentions are paid in the three aspects. First, what is the content of the agreement, means the agreement is if it is directly telling the restrictive nature of this agreement. Second, what are the objectives that agreement seeks to attain. So, main objective of the agreement is analyzed, and third, the economic and the legal context of the agreement is also looked into, because any agreement is finally come into the market, and the economic activity is the final the economic activity will be the final decisive factor to understand or analyze if the agreement is anti-competitive or not. So, for an agreement to have an restrictive effects on the competition within the meaning of subsection 1 of article 101, it must have or it likely to have an appreciable adverse impact on at least one of the parameters of the competition. So, how we can see what in what terms the appreciable adverse impact can be judged. So, it can be judged on the basis of the parameters such as the competition in the market, the product pricing, the output of this agreement, and the impact on the product quality, product variety, or total impact on the innovation. So, the appreciable adverse impact may be judged on any of these parameter. So, if it is having an appreciable adverse impact, then it will be considered as an anti-competitive agreement under the subsection 1 of article 101. And again, these agreements can have such effects by appreciably reducing the competition between the parties. Means the agreement can be between the parties directly dealing with each other, or it may be with the third parties. This means that the agreement must reduce the parties' decision making independence. Means if certain parties or undertakings are part of an agreement, they cannot independently make any decision, and the all total decision will have an adverse impact on the market in terms of pricing or product output or quality of the product, or total on the innovation of the product. And when as per the section 101 subsection 1, if agreement is found to be anti-competitive in nature, then we will or the commission will move into the subsection 3 of article 101. So, basically there are certain exemptions already placed by the European Competition Commission for research and development, or for any R&D activity or specialized research. They allow certain kind of agreements between the undertakings or between the companies. However, apart from this exemption, if there are certain if there are this kind of agreements are in place, then this subsection 3 of article 101 is looked into, and the total the application of the exception rules means, as you know, the article 101 subsection 3 lays down certain exceptions. If the agreements fall under these exceptions, and then it may be considered as pro-competitive in nature. So, basically there are 4 cumulative conditions, 2 positive conditions and 2 negative conditions. So, what are these 4 conditions? First one is the agreement must contribute in improving the production or distribution of the product, or it should contribute in promotion of technical or the economical effect. If we like in general, we can say there should be an efficiency gain by this agreement, and the restriction placed in the agreement should be indispensable to the total process or for the efficiency gain. And third and most important is that if certain this kind of restrictions are placed, then the consumers must get a benefit from this kind of agreement. They receive a fair share of the resulting benefit. So, again the fair share is through getting high quality of the product, or product of a lower price, or product of more technical advancement, or in theoretical sense, if more innovation or technology is coming through that innovation, that is also a kind of indirect benefit for the consumer. And also The agreement must not afford the parties possibility for eliminating competition in respect of a essential part of the products in question. Means it should not restrict the competition. So, these are the 4 cumulative conditions which must be judged under this subsection 3 of article 101 before deciding whether agreement is pro competitive in nature or not. So, now as I told you earlier that now it must be weighed against the anti-competitive or the restrictive conditions of as per the section 101. So, if the pro competitive aspect is heavier or weighs higher than the anti-competitive or the restrictive nature, then the agreement will not be considered an anti-competitive and it will be considered as a normal thing in the market. So, now so this is the basic aspect where under the section 101 the cases has been decided or assessed whether it is anti-competitive or not. Now, let us discuss some of these cases which involves the intellectual property right. So, there are certain case laws through which doctrines have evolved, and because as you know there are various forms of intellectual right starting from patents which is more technical in nature, designs again it is quite like different from the patent in terms it does not involve any technical advancement, only it is exterior shape or the configuration which is being protected. Then there are trademarks which is not that true form of invention as like patent, but also it is very important for any of this company or enterprise. There are plant variety protection, there are geographical indication. So, there are different forms of the IP. So, each of these cases involving different forms of the IP has their own merits and the cases are decided based on the facts associated with this with the IPR. Still then there is a general trend or general overview how the cases has been dealt in the European Union. So, to look into that matter how this transaction involving intellectual property rights or agreements involving intellectual property rights is considered through the eyes of competition policy in the European Union. So, in this direction we will discuss certain cases which should shed light how the IPR and competition law are associated or how they establish the complementarity nature which we discussed in the earlier module. So, one of the landmark cases with respect to this intellectual property right was this maize seed case, or it was a case the decision came from the Nungazer versus Commission of the European Community. Here this case is one of these landmark cases where the issues of exclusive licenses and territorial protection in conjunction to intellectual property rights were dealt with. So, going to the facts of the cases, this is a case where the French Agricultural Research Institute INRA developed a specialized hybrid maize seed and they have this right called plant variety or the breeder's right. So, they transferred all the rights to the seed distributor company in the France, the Nungazer, and the Nungazer got the exclusive license with territorial protection to take this brand as well as to sell the seed and cultivate the seed exclusively in Germany, and no third party including the INRA was were allowed to cultivate or sell the seed in the German territory. So, basically it excluded all the third parties including itself. So, what happened in Germany only this Nungazer was the only company who were supplying the seed and cultivating the seed. So, it had the higher prices. So, since it did not allow any third parties, so the European Commission looked into this case as a violation of the competition law, and it is in violation of this article 101 of this Treaty on Functioning of European Union, and this case was being registered. So, aggrieved by this decision of this European Commission, Nungazer approached the European Court of Justice. However, the European Court of Justice partly allowed this decision. Here the issue was basically the exclusive license and the territorial protection. So, as you know, intellectual property rights gives us the right of exclusivity. Since any of this intellectual property, the inventor has invested money or resources in the research and development, and it also invested quite long time period also. So, to gain benefit, it is essential to provide the inventor certain exclusivity or certain benefits, because he has to incur the or he has to get back the cost which he has invested in the investment. So, basically the inventor wants some profit out of his inventor. So, for that some exclusivity is also granted to the inventor as per the norms of the intellectual property rights. But how about the competition law looks into the static dimension like the lower pricing and availability to the consumer, equal competition between the market players. So, in this context here, in this case particularly, the European Court of Justice looked into the aspect of open exclusive license and the exclusive license with closed territoriality. So, through this case a doctrine has developed which is popularly known as the Mage-Seed doctrine. In this doctrine, the doctrine distinguished between the open exclusive licenses which are necessary for the protection of patents or any other IPR per se, and it distinguished it from the absolute territorial licenses that prohibits parallel import. So, as per this European Court of Justice, the exclusive license with absolute territorial protection is infringes the competition rules, whereas open exclusive license does not infringe the competition rule. Basically, it looked into the case with two rationale. First, whether there is integration of the internal market or not, whether the clauses creating an artificial separation in the national markets, and whether the aim or the aim which both competition law and the intellectual property law share, that is to promote innovation and technology, that are being satisfied or not. So, with these two rationale, the European Court of Justice has looked into this case. So, so the European Court of Justice stated that in open exclusive license, the licensor merely undertakes not to grant other license in respect of the same territory, and it will not compete himself with the licensee in that territory. However, it will not restrict any third party in selling or importing the seed or exporting the seed from that territory. So, basically it is the contract between the licensee and the licensor, and no third party is involved. But when there is an exclusive agreement with territoriality like this case, then third parties are also prevented from exporting or importing the seed or selling the seed in the German territory. So, the court held that open licenses were necessary for dissemination of the new technologies and to encourage acquisition of the licenses, and open licenses emanates from the contractual relationship between the parties. So, as long as they do not affect the position of the third parties, they do not interfere with the article 101 subsection 1. On the other hand, the exclusive licenses with absolute territoriality infringe article 101 subsection 1, because they extend the provision of exclusivity to the third parties who are not bound by the contract itself. So, thereby any agreement which prevents parallel imports or which results in a creation of an artificial market or the separation of the internal market will be considered as violation of this article 101. So, so this case law settled that any agreement that prohibits or limits the parallel trade will infringe article 101 subsection 1. So, this was one of the important decision through in the history of the European competition policy. So, here basically the court looked into that IPR, in one hand the inventor should enjoy this monopoly and he should gain the benefit or profit because he has incurred his he has invested money and time in his invention, similar, but at the same time it should not include any third party to preventing it should not include other parties from selling or getting benefit from that invention itself. So, in that similar direction, the next doctrine was the exhaustion of right doctrine. So, as you know, the intellectual property rights are given for a limited period of time, and like any other right, once so there is a confusion, or there is a question always like, if I have a intellectual property right associated with some product, so once I sell the product, does I have the same right with over the product, or I don't share any more right with that product. So, in line with the competition policy, the exhaustion of right doctrine has evolved through this classic case, where Constant and Grunding versus the Commission, where going to the fact of the cases, Grunding was a German distributor of the electronic goods. So, he chose Constant to distribute the electronic goods in France, and again he was the Constant was chosen as a exclusive distributor in the France, and no third party were allowed to distribute this electronic good, and Grunding has transferred all this trade name and brand of this electronic good to Constant. However, there is another company who started parallel importation of the goods from Germany and started selling it in the France. So, Constant and Grunding together complained about this third company to the Commission. However, the Commission said that the agreement between Constant and Grunding is in violation of this article 101, because the exhaustion of the rights. Through this case, now the Court of Justice has come out with this doctrine known as the exhaustion of right doctrine. So, so as per this right doctrine, the exclusive right cannot be used to artificially split up the common market along the national borders. Therefore, the holder of an IPR in a member state cannot oppose the import of a product protected by a IPR into that member state. Even though you have a IPR associated with some product and you already have a channel to sell that product in a market, you cannot oppose the import of that product from other market to that into that market, because you are selling that market, selling in that market. So, so basically it is applicable throughout the European Union, and it plays a significant role in protecting the free movements of the good. So, as per this, it means once you have sold this article, you do not share any other right with that product. So, now the third party is free to sell that product or use that product in any way. So, this is the basic concept of this exhaustion of right doctrine. So, this one is also in line with the competition policy. And in the same direction, one more important case was this pro Nupita case, where the court has analyzed the case where whether the franchisee agreement are whether the franchisee agreement can be judged on the basis of article 101 subsection 1 or not. So, as you know, in a franchisee agreement, basically all the business name, trademarks, know-how, etc., are transferred to the franchisee, and the franchisee is supposed to maintain the trademark. Means there should not be any compromise on this quality or brand name of this franchisee, and also there should not be any leakage of this know-how or these other secrets which are being transferred through this agreement. So, here in this case the European Court of Justice stressed that the franchisee agreements are not a typical distribution system, but the way it is a way by which the undertakings derive financial benefit from their expertise without investing their own capital. So, even though the franchise in a franchisee agreement the business transfers is trademark or that is which is a kind of intellectual property, but it is not it does not interfere with the competition law. In some of this franchisee agreement, there are terms like where the franchisee cannot start his own business until a limited period of time, but still these clauses also in general do not interfere with the competition laws. So, there are like as I mentioned earlier also. So, as per the nature of this intellectual property right, the cases are looked in different looked from the different angles where when we talk about this competition law or competition policy in European Union. So, as this guideline also I mentioned earlier, that it suggested that there is a complementarity between the intellectual property law and competition law, where they share common goal of consumer benefit and promotion of the innovation and technical know-hows. But still there is a difference in the sense that the competition law generally looks the agreements in terms of static benefit, means whether there is a equal competition among the competition or not, whether the consumers are getting the product in a lower price or not. But when we look the cases from the angle of intellectual property right, we generally think about the benefit for the inventor, also for the consumer, in terms that the consumer is getting a new product or better quality product where technical advancement is there, and it also promotes innovation. So, IPR majorly focuses on dynamic innovations or dynamic efficiency, whereas the competition law focuses on the static efficiency. So, depending on the merit of the cases, it is always static efficiency versus the dynamic efficiency. So, in case of agreements which involves the intellectual property right, equal weightage should be given to static efficiency as well as the dynamic efficiency, means whether there is a technical advancement or not, whether the inventor or the proprietor of this intellectual property right getting due benefit or not, that also should be taken into consideration. And as we know, it is a kind of exclusive right. So, in the agreements there are certain chances that there are certain restrictions may be in place, but again as mentioned in this article 101 section subsection 1 and subsection 3, they should be judged case by case basis. So, finally, through these cases we have now we have a brief idea about how article 101 is assessed in case of these dealings involving intellectual property right. So, in continuation to this, we will now discuss about how article 102 is like assessment of article 102 with respect to various intellectual property right agreements. So, in the next section we will discuss all these things. Thank you.